No, I would say go ahead.
Okay. All right. Lisa, are we ready to go on the technological side? Okay. And is this now open to the public?
Yes.
All right. All right, perfect. So I'm going to call to order the July 13th, 2020 RAD committee meeting. And just want to note for everyone present that this is a Zoom meeting. And like in a regular in-person meeting of the board, it's being recorded and will be archived on the State Bar's website. Lisa, can I have you please take roll?
Yes. Chen? Yep. Cisneros?
Here.
De La Cruz?
Here.
Duran?
Here.
Iglesias? LeBron?
Here.
Manning?
Here.
Petula?
Here.
Slig?
Here.
Stalling?
Here.
Steinbrecher?
Here.
All right, do we have a quorum?
Yes.
All right, perfect. All right, so we were going to take the items on the agenda in the order that they appear, with the exception of the closed session. And so after all the open business items are completed, we'll go into that closed session meeting pursuant to Government Code Section 11126C2. We will be taking public comment today, and for those of you who are participating via Zoom, you should have a function for virtually raising your hand. If you wish to make public comment at this time, please use that raise hand function. For those of you who are participating by phone, you may virtually raise your hand by pressing *9. That's the star key, then the number 9. And doing so will alert us that you'd like to make comment. So Lisa, can you see if there are any members of the public who wish to make public comment?
Actually, our staff is doing that. Ellen and Louisa.
Okay.
See, I know that we had a few who were interested. Ellen and Louisa, can you tell us?
Hi,
So I'm monitoring. Go ahead, Louisa.
I was just going to say we do not have any hands raised at the moment.
Okay, so if you see a hand raised, can you just bring that to our attention at a break in the meeting, and we'll do public comment at whatever point it makes sense. Just generally, I would ask that the public commenters please limit their comments to 3 minutes, as we do have a full agenda, and the commentator will be given 30 seconds or a 30-second warning. And then at 3 minutes, we'll turn off your microphone and call the next member of the public. So any hands raised? Going once, going twice. All right, we'll go to the chair's report. And because it is a packed agenda, I will defer my chair's report for the various parts of the meeting. So we'll go to consent agenda. Is there anybody who wishes to take any items off the consent agenda? Okay, and hearing none, I would entertain, I think we just need a second for this.
I second it, Debbie.
All right, second by Debbie. And then Lisa, can you please call the roll?
Yes. Chen? Cisneros?
Aye.
De La Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Yes.
Manning?
Yes.
Petula?
Yes.
Selig?
Yes.
Stalling?
Yes, but I don't think I have a vote unless it's a tiebreaker.
Okay. Steinbrecher?
Yes.
All right.
May I interrupt for a moment just to note that we have a member of the public who has raised their hand virtually.
Okay. I will take public comment then now at this point. Sir or ma'am, could you please identify yourselves? You have 3 minutes due to the nature of this packed agenda.
Yes, thank you. I was having issues with my video. Can you let me know if there's an issue with audio? Are you able to hear me?
It's pretty faint on my end.
Across the board. Okay. I will try to come back and then through another device. and raise my hand at that time if that is okay. Is that acceptable? This is Jean Chan. I'm commenting on behalf of the Association of Citizens Defense Council regarding 5.137.
And this is Sean. I can't really hear the speaker at all, so maybe we can try to,
Yeah.
maybe staff can work with this person to get a better line so we can hear.
Yeah, so
What I made out of her request was that was actually exactly what she was requesting to do, is to call back in on a different line. All right.
Okay, so we'll take public comment then from the commentator once a more secure line is established. Okay, anybody else with their hands raised? Okay, we'll go to item 3A, consideration of attorney self-assessment models. Randy DeFantorum.
Good afternoon, members of the board committee. I'm Randy DeFantorum, Director of the Office of Professional Competence. Business item 3A is a staff recommendation for the development of an attorney self-assessment program. The board did discuss the concept of a self-assessment program back at its January 26th and 27th, 2018 strategic planning meeting. And this item does come to the board in response to a specific objective in the strategic plan. Goal 2, Objective E, essentially provides that the state bar should evaluate various models of attorney self-assessment programs by December 31st, 2020, and select a model for development of an implementation plan. At the 2018 planning meeting, the discussion included a presentation on Colorado's state bar self-assessment program, and it was learned that a self-assessment program contributes to public protection by facilitating a lawyer's self-awareness of knowledge gaps in law office management practices as well as professional responsibilities. Self-awareness of these gaps in turn lead to changes that can enhance the competent practice of law. The model being recommended by staff is an online interactive program capable of offering multiple subjects in separate modules. Using the program in accordance with the staff recommendation would be voluntary as well as anonymous, and this is largely to mitigate any chilling effect of a program that is being administered by the attorney disciplinary agency. It's also being recommended that MCLE credit be available and that non-personalized aggregated data be collected. The recommended first topic would be client trust accounting practices with a plan for the selection of future subjects to be jointly considered by the Office of the Chief Trial Counsel and the Office of Professional Competence. The data collection aspect of a self-assessment program is a separate benefit with the analysis of collected data serving as a tool to evaluate, identify, and hopefully proactively address common forms of avoidable lawyer misconduct. Regarding the basic format of a program, the agenda item summarizes the pros and cons of the most common implementation models. I've provided links to the actual programs in attachment A, and in attachment B, you can see some screenshots of what those programs interfaces look like. The basic format could be an online interactive module, which is the staff recommendation, but it doesn't have to be. It could be a non-interactive online checklist, such as a fillable PDF at the website, or even something more low-tech than that in terms of an actual physical workbook or checklist. And I don't know if you remember back in the day when people read magazines, you might read an automotive magazine, Motor Trend, and it might have an article about maybe you're interested in buying your first sports car, and they would have a series of questions that you would rank yourself. And at the end of answering questions like, do you prefer 0 to 60 acceleration or top end speed? Are you into tinkering and adding a turbo or not? And you take all those questions, and at the end, it would tell you, are you a American muscle car person or a luxury import brand? What does the self-assessment reveal about yourself? And that's what all of these formats have in common. It's really just the deployment. And some have certain advantages over others. If you're talking about a workbook or a checklist, that's probably the most anonymous you can get. An online interactive program, though, would give you the ability to collect that data, hopefully aggregated and non-personalized, so that you can use it for analysis. The recommendation for the interactive online format in part is informed by the State Bar's experience with the e-learning initiatives. And this includes the first of those, the 10-hour new attorney training program. And Trustee Stallings served as the board liaison, I'm sure he remembers, to the working group that developed the subjects for the 10-hour new attorney training program. And I recall his good counsel to that group when he cited Michael Jordan and said, for the concept basically that rookie NBA players often don't know what they don't know. And while that might be most true about new attorneys, the concept of implementing a self-assessment program is actually a recognition that even experienced practitioners might have blind spots like that, whether it's in trust accounting practices or with, for example, emerging issues in technology in the practice of law. After we surveyed the basic format of a program, staff took a deeper dive and gathered input from some of the states that have already implemented programs. We had the goal of learning a regulator's actual experience with a self-assessment program. For example, the basic question of, if you build it, will they come? The most detailed information was provided by the representatives, not surprisingly, of Colorado and the Illinois program. Both these states have programs that use the interactive online format, but they have a major difference. Colorado's program is fully voluntary, while the Illinois program is a mandatory program for practicing lawyers who lack malpractice insurance in that jurisdiction. Both, however, reported positive experiences, and that is covered in the agenda item. But what I'd like to do in the interest of time, we do have a full agenda, is jump to the table of issues and recommendations that appear on page 5 of the item. As this was developed after considering all of the information we collected from Colorado, Illinois. We also, I think, talked to a couple of other states that didn't provide a whole lot of information. If you look at the issues and the recommendations there, these are the points on which staff really need some guidance, because if you have a consensus on these issues, then staff will know the necessary parameters for developing the actual implementation plan. For example, the input from Colorado, as well as from our own OCTC staff, support the strong recommendation that any self-assessment program be allowed to be used anonymously. Similarly, the program is being recommended not as a one and done initiative. Instead, it should be, again, a multi-subject program, something that we can roll out over time, and something that can be periodically updated based on what we see in the data that we collect. So maybe I'd like to just pause there for a moment and say, does anybody, I doubt anybody has any questions about the basic format, which is a recommendation for an online interactive module, much like our e-learning experience. But on page 5, we do have the various issues: MCLE, capturing data, allowing non-licensees to have access to the self-assessment program. If there aren't any questions about those issues, the proposed board committee resolution appears on page 7, incorporates by reference that this is the staff recommended model, as well as the approach for the subjects with, again, client trust accounting being the first subject. So I'll stop now while I'm ahead.
All right, does anybody have any questions for Randy about the table on page 5 or the content of the resolution?
Brandon, I don't have any questions. I'll move the resolution recommended by staff. Duran.
Second.
This is Jose. I'll second it.
Okay. First by Ruben, second by Jose. Lisa, please take roll.
Juan? Gonzalez?
Aye.
De La Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Yes.
Manning?
Yes.
Bertula?
Yes.
Deleg? Saleg? Okay, he's on mute. Okay,
Yes. Sorry.
Stalling?
It's not a tiebreaker, so I don't think I get a vote.
Okay, Steinbrecher.
Yes.
Okay.
All right, resolution passes. Randy, thank you so much to you and your team. And I think this is an important step forward for RAD and for the bar, and hopefully allowing attorneys to get ahead of some of the common pitfalls that they can get into. So I do appreciate the Michael Jordan quote. I'm always happy to lend my encyclopedic knowledge of sports related quotes. All right, moving on to item B. And this is proposed amended rules of professional conduct 1.1 and 5.4. I return from public comment, and I believe we have Andrew Tuft available for this.
Good afternoon, everybody. This item follows up on action taken at the March board meeting. At that meeting, the Task Force on Access through Innovation of Legal Services presented their list of recommendations to the board, which included circulating for public comment proposed revisions to Rules of Professional Conduct 1.1 and 5.4. The board agreed with this recommendation, and those two rules circulated for a 60-day public comment period. However, because the ADJOURN task force sunset on March 31st, the board directed the Committee on Professional Responsibility and Conduct to receive and review the public comments submitted concerning these two rules. And this item presents their recommendations. With respect to Rule 1.1, which is the competence rule, ADJOURN recommended that, that a comment be added to the rule, providing that a lawyer's duty of competence encompasses a duty to keep abreast of the changes in the law and its practice, including the benefits and risks associated with relevant technology. The proposed comment language is derived from comment 8 to ABA Model Rule 1.1, and is also consistent with the language adopted by the 38 other jurisdictions that have a similar comment to their competence rule. 13 public comments were received, and the comments that were opposed to the rule fell into what I would describe as two buckets. One group of commenters felt the comment would unfairly expose lawyers to discipline by failing to keep up with technology, which is something that is constantly changing. And another group of commenters thought the rule should be narrowed, thought the comment language should be narrowed by stating that the duty only applies with regard to obtaining the requisite learning and skill relevant to a particular matter. COPRAC declined to make any revisions to the rule as proposed. As I noted, the comments language is consistent with the comment to the ABA model rule, and those adopted by a majority of US jurisdictions, and is not intended, nor does it change existing law. And the proposed comment is also consistent with a handful of current California ethics opinions. COPRAC, along with ADJOURN, believes that there's great value in drawing the attention of practitioners to this aspect of their duty of competence. And the committee further believes that the comment should not give rise to a risk that lawyers will be disciplined for failing to keep up with technological changes in areas unrelated to the practice of law or their specific practice. And the reason for that is the committee noted that the black letter text of the rule is the basis on which discipline can be imposed, and the duty stated there applies only to the lawyer's performance of legal services. And in addition, the rule does not require a lawyer to become an expert in technology, as it permits a lawyer to fulfill their duties by associating with another lawyer or another person who has such expertise. And so, following consideration of the public comments received, COPRAC is recommending that RAD and subsequently the board approve Rule 1.1 as proposed by the ADJOURN task force. And Chairman Stallings, I don't know if you wish for me to stop here. This agenda item is somewhat unique. We are discussing 2 rules of professional conduct, but it contemplates different action for each rule. I'm happy to continue to discuss Rule 5.4, but I don't know if you wish for me to stop here for questions and/or entertain a motion.
Yes, I think questions would be a good time at this point. Any questions on 1.1? All right, hearing none, I will move on to the rest of your presentation, and then we'll take both of the recommendations. We'll probably do it separately just so the record's clear.
Okay, great. So with respect to Rule 5.4, this rule is entitled Financial and Similar Arrangements with Non-Lawyers. ADL's recommended amending the existing paragraph A5 to the rule by expanding the existing exception for fee-sharing arrangements with a non-profit organization to include an exception providing where the legal fee is not court-awarded, but arises from a settlement or other resolution of the claim or matter. The lawyer may share or pay the legal fee to the nonprofit organization, provided that the nonprofit organization qualifies as a Section 501c3 nonprofit under the Internal Revenue Code. And this exception is modeled after District of Columbia Rule 5.4, which has a similar provision. 14 comments were received concerning this rule, and COPRAC was persuaded by a comment submitted by the California Lawyers Association Ethics Committee, who suggested that that because this exception was significant enough, it warranted a new subparagraph A6. And in addition, the CLA Ethics Committee, along with a few other commenters, stated that such a fee sharing arrangement would in fact constitute a significant development, which would require communication to the client in every instance. And as a result, COPRAC agreed, and they broke out this exception to a new paragraph A6. And they also added the safeguards and protocol, which are reflected in current Rule 1.5.1, which addresses fee divisions between lawyers. For the non-ethics nerds, Rule 1.5.1 requires, among other things, that lawyers enter into a written fee agreement to divide a fee, and the client must consent to the fee division at the time the lawyers enter into the agreement to divide the fee, or soon thereafter as is reasonably practicable. And they also must agree to the terms of the division. And finally, the total fee charged may not be increased solely by reason of the agreement to divide the fees. And one last note, in addition to those revisions, COPRAC also added a comment, a new comment 4, following a suggestion from the Orange County Bar Association Ethics Committee. And this new comment states that a lawyer or a law firm who has agreed to share with or pay legal fees to a qualifying organization under paragraphs A5 or A6 remains obligated to exercise independent professional judgment in the client's best interests. And because these recommended changes are significant changes to the rule that previously circulated for public comment, COPRAC is recommending an additional 45-day public comment for this rule.
All right, any questions as to 5.4 and the request for additional public comment period? Okay, hearing none. Can we take all of the recommendations as a whole, or would you say break them out?
I think that I need them broken out.
Okay.
Here,
So
everyone, does this help? Is this helpful to have this? These are all the resolutions.
That's correct. This is Andrew. So the first two are with respect to Rule 1.1, which is adopting, approving the rule as recommended, and then also directing staff to submit the rule to the Supreme Court following action taken by the board. And then the bottom two are typical resolution language when issuing a rule or other item for public comment.
And then Andrew, the last one should the Board of Trustees concur in the proposed action, passage of the following resolution is recommended. Can those two be lumped in with the first two resolutions?
Yeah, I defer to board staff on this. It's my understanding that after RAD takes action, this resolution language will go to the consent agenda on the board meeting, but I'm willing to be corrected if I'm mistaken.
Yeah, that's correct, Andrew. So from should the board concur down, that goes to the board at the meeting on the 16th. Everything above that is for RAD today.
All right, so as to the first two resolutions in regards to Rule 1.1, do I have a motion?
Moved, Jose.
Okay, Jose moves. Is there a second?
Juan.
I'll second that.
I'll go with Ruben. Tie goes to Ruben. Sorry, Juan. Okay. All right, Lisa, please call the roll.
Chen? Cisneros?
Aye.
De la Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Recusing myself.
Manning?
Yes.
Bertula?
Yes.
Saleg?
Yes.
Stalling?
It's not a tiebreaker, so no vote.
Okay. Steinbrecher?
Yes.
1, 2, 3, 4. Oops. 7 in favor?
That's 7 in favor. All right, motion passes. In regards to the second set of resolutions regarding Rule 5.4, any further discussion, or can I have a motion?
Jose again, I'll move.
Juan, I'll second.
Okay. Jose with the first, Juan with the clear and decisive second. Lisa, please call roll.
Chen? Cisneros?
Aye.
De la Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Yes.
Manning?
Yes.
Bertula?
Yes.
Leg?
Yes.
And Steinbrecher?
Yes.
All right, motion passes. Going now to the next agenda item. Item C, proposed amendments to rules and proposed new rules regarding electronic service, electronic signatures, and trial exhibits. This is a request to circulate for public comment. And I believe we're going to be joined by Melanie Lawrence and Steve Moad. So welcome.
I'll pull that up after they're done.
We have Melanie and Steve here to present.
We have Steve. I believe we had Melanie, and I think she was going to start off the presentation.
She's there. Can't hear her.
Can't hear her.
You hear me now?
There we go.
Okay, perfect. All right, modern technology. Okay, so this is a proposal to permanently allow parties to serve documents electronically, to utilize electronic signatures, and to use and exchange trial exhibits electronically. These issues have been on our minds for some time now, but because of the pandemic and mandatory telecommuting, it's really moved to the forefront of our minds. The interim rules that are in place have really paved the way for these permanent rules, but the proposals that we're making are much more forward-looking, allowing us to modernize our practice. The proposals would be particularly impactful to the parties by allowing the use and exchange of trial exhibits electronically and moving away from mandatory paper environment. You may or may not be aware that the court has begun doing trials by Zoom. They started last week. And given what is currently going on in our state in particular, we can imagine that this will be going on for the foreseeable future, where we will be working in a remote environment. And the requirement that parties exchange exhibits electronically is particularly impactful for the parties and particularly for our office. It requires our staff to come into the office to produce a number of different copies of exhibits. And depending on the trial, that could be hundreds, if not thousands of pages. And all of those exhibits also have to be placed in binders and tabbed individually. And so given the environment that we're living in, it's really no longer tenable to continue our practice in this way. And looking ahead, it's just not consistent with a modern day practice. So that's the basis for the proposals. And I'm going to turn it over to Steve, who's going to give some more detail.
Thank you. So we, as Melanie pointed out, the interim rule has really paved the way for what we're doing here. And in fact, almost all of the changes that we are proposing here in a permanent rule are in the version of the interim rule that was just passed on consent a moment ago. The only real difference, as Melanie pointed out, we are incorporating electronic signatures here, which is in another place in a different form in the court's general order. We are also including the electronic trial exhibits, which is very important, as Melanie highlighted. And the only other thing that is not included in the interim rule is that we have provided for an electronic service cutoff time of 5 p.m. to address attorney wellness issues. I do want to thank our partners in the discipline system, the court and the Association of Disciplinary Defense Counsel. We have had several opportunities over the last few months to engage in open and honest communication about this proposal. And we've gotten their input, we have heard their concerns, and in most cases, I think that we have tried to amend our proposal to mitigate or completely address their concerns. That has not been, that's not something we've been able to do in every case, however. There are a few places where we couldn't reach consensus with the ADDC and the court, and those areas are, for the most part, highlighted in the agenda item that you have before you. I am also aware that the court has sent an email to the RAD chair expressing some concern about multiple sets of rules and in addition making several specific requests about the agenda item. The multiple sets of rules issue is also addressed in the agenda item because OCTC does acknowledge that it is a concern. Unfortunately, we just feel more strongly that the bigger concern, particularly in light of the uncertain future of e-filing, is that we move forward with the electronic trial exhibits sooner rather than later. The other specific request that the court makes is to include, as determined by the court at the end of the definition of document in proposed rule 5.426. I'm not sure that that's necessary in order for the court to adopt rules of practice defining documents, but nor are we necessarily opposed to including that in the final proposal if the board feels it's appropriate. There's also some concern about 5.62 and about heightened security around electronic signatures when paper signatures, paper documents don't have similar protections. And I think it's important to highlight that these rules are based on the Code of Civil Procedure and on the California Rules of Court. So we're not inventing the wheel here, so to speak. Second, I would also point out that a paper document, which requires an original ink signature, would be subject to a handwriting analysis or other authentication to establish who the signatory is. And with an electronic signature, which by definition can be an image of a signature that may or may not have been applied to a document by the person whose signature it purports to be, and can also include a typographic signature, which is a /S/ followed by a typewritten name. And certainly there is no authentication that can be performed on that type of a signature to ensure that it was signed by the person who purportedly signed it. This becomes important, particularly as we talk about documents submitted under penalty of perjury, which is the area where the heightened security requirements of the signature come into play. In other situations, it's merely including that image of the signature or the typographic signature, etc., that would deem that document to be signed. Another area of concern voiced by the court was electronic exhibits to respondents. We have addressed this in the agenda item itself. I certainly understand the court's concerns. We respectfully disagree, however, and plan instead of giving anytime a respondent requests paper documents, we instead plan to meet with them and work in good faith with respondents and respondents' counsel to provide paper exhibits where necessary. Another area is providing paper exhibits to the court, and the court is asking to maintain a requirement in the rule that the parties provide 2 copies of paper exhibits in addition to the copy that would be lodged with the Supreme Court. And these exhibits, as Melanie pointed out, must be presented in tabbed binders with labels on each binder, and this has a real impact on our work. And we believe that providing the court with 1 copy of in the format of their choosing is the best course to balance the competing concerns. And finally, the court advocates for a 60-day public comment period. As I mentioned, the exhibits have a significant impact on our operations, and this is not covered by the interim rule. We envision remote work will continue, as Melanie pointed out, for the foreseeable future, and this is something that we would like to see change sooner rather than later. A 60-day public comment period, in addition to the time required to get the item posted, to process the comments made, and then to prepare a new agenda item in time for posting in compliance with open meeting laws, would make it very difficult for us to meet that September cutoff for the September meeting date of the board. And that means the earliest we could have this rule in effect, even if everything else goes smoothly and the board chooses to adopt it, would be at the November meeting. And that is significantly less desirable. We could conceivably, if the board chooses, expand it to a 45-day meeting. It's just the way that the July and the September meetings are calendared, that there's a little bit of extra time that would make that feasible in this particular instance. So if the board wishes to do that, we certainly would have no objection.
Brandon,
All right.
can I ask a
Yes.
question?
Yes, Sean.
Great. Thank you for the presentation. So, Steve, let me just ask you, I have a couple other thoughts, but just on the last point you raised about the 60-day comment period, is it only the trial exhibits that you think requires a shorter comment? In other words, could we send out just trial exhibits for 30-day comments and the rest of them for 60 days? Because, and this will preface one of my other comments, I mean, you've just teed up a lot of detail in terms of issues that people have sort of teed up for decision. And at least for me, it's a lot to follow at once. So we may need a presentation that's more like in a table format to help us study this. And we're just sending this out for public comment at this point. But and also that the September meeting tends to be a shorter meeting because we have one meeting for the old board and one for the new board. So if the trial exhibits and maybe 1 or 2 other issues are especially time sensitive, maybe we could do those for 30-day public comment and get them on in September. And if there's a bunch of other issues that aren't quite as urgent, maybe they can be deferred until a later meeting. So I just throw that out for your thoughts.
My thoughts are that, and I'll let Melanie respond also, or she should be allowed to respond as well, is that we could certainly do that. I would simply point out or highlight that most of the other changes are already incorporated in the interim rule that this board just adopted. So I think that it really is the it really is the trial exhibits piece of it that I think the court has the most concern with.
Yeah, I mean, I think for us, and I think for probably parties who are practicing before the court generally, the exhibits are the most significant and pressing issue. So if there's a way that we can send it out separately, we can certainly entertain that.
Just to add to what Melanie and Steve indicated at the beginning of their presentation, is that this has been a involved process with our stakeholders at this state bar court, as well as ADDC. I know that there has not been perfect alignment with all parties, and that I think all along we've talked about how in the public comment period, those different viewpoints could be fully expressed either by state bar court or by ADDC. So that way members of RAD could fully understand the different issues and concerns raised. I am not opposed to the 30 days for the trial exhibits, and then either a 45 or a 60-day. I think that comment period for the rest of the agenda items. So to me, that makes sense. And I don't know if there's any further questions or comments or questions from the rest of RAD.
Brandon, I think this is Ruben. I think the only comment that I would make is with respect to the shortening to 30 days for the comments on the trial exhibits, is that the issue has been discussed at the bench bar committee with all the stakeholders at the table for some time now. Not a long time, but certainly this is not new to anybody. And so I'm hopeful and confident that folks who care to comment are prepared to do so, and I assume that they will relatively quickly. I'm hoping so, at least.
Well, maybe 30 days is sufficient then, if this is really I mean, it doesn't feel fully teed up for us to decide. I mean, to decide now, other than the sending out to public comment, but because we don't have the public comment and all that sort of stuff. But anyway, I'm flexible on that. I just was proposing if we could split it, or we could just do it all for 30 days.
I know one of the things that I heard at the benchmark committee is that ADDC has not had a chance to fully meet with its members and put together a package that they believe might reflect what their members' concerns might be. So if we did a 45-day comment period for everything but for the trial exhibits, I think that should hopefully give ADDC a chance to bring their concerns to this body.
I'll make that motion, Brandon.
Okay.
I'll second.
All right, so first by Ruben, second by Sean. Lisa, can you put up the resolution and then put in the changed comment period timeframes?
Okay, so okay, sorry. So this is what I'm changing?
So
Gonna peel off the, I'm sorry.
I think it's 5.101.1.
That's the trial exhibit one, yes.
5.1, this one right here?
Yeah.
So
let's maybe take that entire line and then we'll do a new resolved item that only includes 5.101.1.
sorry, okay, sorry.
And that 30 days above would change to 45.
Yeah.
So if you scroll up, Lisa, there's a 30-day notation. It should be 45 days.
Okay. And then this should be 45?
Yep.
And what are we saying here?
And then so what we'll do is we'll have a new resolved. So just copy the language from the first resolved.
This one or this one?
The top one.
This one?
Nope. Go down one. Yeah, that one right there. Yep. So just copy that, and then underneath, further resolved, and then include the language of the rule 5.101.1.
Right there.
Yep, and then change the period from 45 days to 30 days. All right. Ruben and Sean, are these changes on the screen consistent with your motion?
I think so, except for the last two paragraphs that's resolved with respect to 5.101.1 should be moved up above the final further resolved about this authorization for release for public comment is not and should not be construed as, etc. So just flip those two so that the last resolved is as it was.
I'm sorry.
I know that's no fun and it's not easy. I'm sorry.
Okay.
So essentially, where it says further resolved, that should be the very last thing on this resolution. Just move it down to the bottom. There you go.
Okay.
And period, and then you just have to, you added some extra language and is further resolved, but that should be removed as well. I'm pointing at my screen and you can't see it. I love it.
Should this be added further resolved right here? And it is further or just resolved?
No, add the further.
Yeah, but you had typed in and is further in the text, in the paragraph right before that.
Okay, so this is gone. Oh, this.
Yeah, there you go.
Delete.
All right. So Ruben, are you satisfied with that?
Yes, I am.
And then Sean, are you satisfied?
Yes.
You can just
All
call
right.
me Angelica Schuyler.
I wish we had, the powers of the force so we could see where your finger was pointing. That'd be pretty cool. So hey, Zoom, if you're listening in, let's have that as a function. All right. Lisa, can you please take roll?
Yes.
Oh, Brandon.
Yeah, Sean.
Sorry. I just have one substantive comment. We focused a lot on procedure. Yeah, we'll get public comment on this, no doubt. But the one thing that caught my eye on this is this 5 p.m. service deadline. That seems really anachronistic to me. And as a practicing lawyer, I do not think it contributes to lawyer wellness. I think one of the best things that's happened in my practice personally is that we don't have to stress about getting a filing out at exactly 5 p.m. When e-filing first became prominent, there was this debate. There was a tendency for people to be staying up till very late to take advantage of the midnight deadline. And that sort of has faded away and has become less of an issue, at least as far as I've seen in daily practice. And I think that there was also, there were a lot of problems with different jurisdictions having different practices. So most jurisdictions now, in fact, I can't think of any that doesn't follow a midnight rule anymore, because it was just really confusing to have a patchwork, like this court is 4 p.m. and this court is 6 p.m. and this one is 5:15. Just created a lot of problems. So I think we'll probably hear public comment on this, but I just throw it out that I'm not sure that's a very timely proposal, frankly, and I'm not sure it's a good proposal. I think it's counterproductive to the concept of making it easier for practicing lawyers to meet deadlines.
Steve, do you want to briefly respond to that?
Sure. I agree that we will probably receive some public comment on it, and I don't necessarily disagree that there is a world shift that this is part of. I do think that the National Task Force for Lawyer Wellbeing, as well as some individual states, Delaware being one, have moved back to the 5 o'clock deadline because of the very wellness issues that are represented here. I think that recognizing that a patchwork of states could potentially be problematic. I don't know necessarily that we contribute to that by adopting rules that model attorney wellness issues, because most of the people who are practicing in state bar court are not practicing in other states that have midnight deadlines. But I think that there is frankly a movement afoot, or at least some encouragement of a movement to revert back to a 5 p.m. deadline for attorney wellness issues.
All right, thank you, Steve. And just briefly, one thing I do want to let the committee know about is that Ruben and I have engaged in extensive discussions with State Bar Court about e-filing and about the timeline for an e-filing system. So I anticipate that we're going to have a proposal to RAD, hopefully by the September meeting, but most likely by November, that would just give an update on what sort of options there are for e-filing for State Bar Court matters. State Bar Court did raise an issue regarding the economic impact, the staff costs, and in the communication we received this today, there was a concern that there would be some staff impact. So I would ask that State Bar Court get with State Bar staff members and be able to advise the board when this comes back from public comment on any sort of increase staff costs. All right, any other comments, questions, concerns before we call the roll? Okay, hearing none. Lisa?
Okay. Oops, hold on. Chun? Cisneros?
Aye.
De la Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Yes.
Navin?
Yes.
Petula?
Yes.
Blake?
Yes.
Darling? Steinbrecher?
Yes.
All right, motion passes. Would now be a good time to pause to see if there's anybody who wishes to make public comment. Has any hands been raised? Okay, hearing.
Couple of hands just got raised.
Oh. All right, let's take a pause then. We will take public comment. First individual, please keep it to 3 minutes.
I'm going to ask, so the microphone has been made available to David Carr, and now that you've unmuted it, you'll have 3 minutes, Mr. Carr.
Yes, I need to offer public comment on the next agenda item. I don't know if we're there yet.
On item D?
Item B, no, the 5137 proposals.
Yes, that's the next one, so it's timely.
Okay, thank you very much. I appreciate the opportunity. I'm here today as the authorized representative of the Association of Discipline Defense Counsel, and my colleague Gene Shaw, I believe, is joining us by telephone. And I'll be very brief. The purpose of State Bar discipline proceedings, as we all know, is to protect the public. The purpose is not to punish misconduct. The purpose is not to raise revenue for the State Bar. Unfortunately, we have a statute that has been passed some time ago, and now we have moved to implement that statute with a rule, and we now have some enabling amendments before the committee today to consider whether to put forth for public comment. ADJOURN believes that the Board of Trustees is moving in the wrong direction. As opposed to further implementing this statute, which we view as completely incompatible with the purposes of discipline, the the board should be moving toward convincing the state legislature to repeal this statute and prevent some of the harm to the public protection function of the state bar that we see as inherent in the idea of the state bar court moving from a court whose function is to determine appropriate discipline to a court who is now going to be increasingly called upon to litigate the issues of whether the sanction, a punitive sanction, is appropriate. And we see examples of this in the very rules that are before the board today. My colleague Jean Shaw should be here, hopefully on the phone, and she has some further comments. Implementing these rules and further implementation of the sanctions idea in state bar court is going to significantly slow down the work of the court. It's going to create huge disincentives for respondents from settling state bar matters. We're going to see more trials, and more of the stuff that happens at trial is going to be devoted to litigating the issue of whether the sanction is in the appropriate amount. We believe the board should be moving in the opposite direction. We believe the board should be doing its best to convince the state legislature that this legislation is not compatible with the state bar's public protection function, that it is in fact harmful to the public protection function and should be repealed. And with that, I'll turn it over to Jean if she's on the phone.
She is, and staff will make her microphone available to her. And Ms. Chaw, when you see a microphone icon, go ahead and unmute that, and you will have 3 minutes to deliver your comments. We still have David Carr's microphone activated. There we go. Ms. Chaw?
Are you able to hear me now?
Yes, we are.
Oh, great. Thank you. Good afternoon. This is Jean Shaw, Second Vice President of the Association of Disciplined Defense Counsel. And thank you so much for your time. What I want to mention in further of some of the remarks that Mr. Carr stated are the concerns that the ADDC has at this moment. It's still somewhat early, but we would hope that we can start a dialogue regarding some of our concerns. One of the first, or the main one, is regarding discovery, which I'll get to in a minute. But the bottom line is that sanctions by definition are punitive. And so although it does go to benefit CSF, which is a good thing, we submit processes to assess whether sanctions are appropriate. And the amount of those sanctions are needed prior to their implementation. So we would say, let's consider a greater level of due process if sanctions are going to be implemented regularly. Until the due processes are established, any proposed amendments should be stayed their development, and careful analysis is performed by the State Bar Court, OCTC, and the Board of Trustees, and hopefully with the input of the ADDC. It does appear to run contrary to the mission, and the Supreme Court case in Ray Brown, 1995 case, states that the aim of disciplinary matters is not to punish, or it's not for punishment or retribution. So keeping that in mind. A second point of 6 I have is that the amendment to Rule 5.137 may cause an impact that is adverse to and have a disparate outcome of suspensions and disbarments as it affects minority attorneys. As the Board of Trustees may be familiar with, in November 14, 2019, there was a report that came out that supports that concern. Negotiated settlements, point 3, is that negotiated settlements would be delayed. And the concern is that there are a majority of dispositions where a sanction may at first appear to be a suspension or disbarment, but at the end of the day, it would be a state suspension or perhaps less. So having an evaluation of whether the sanctions would apply at an early stage might be premature, and whether an attorney is likely to seek a waiver may cause delay in a settlement of a case if there is a stalemate. Another concern is that Perhaps a way to approach it is having a separate hearing that may be appropriate for the determination of sanctions. And
Ms.
it
Shaw,
could be an
I'm going
emotion
to ask you to
eliminate.
wrap up. Your time has expired. Can you please wrap up? Thank you.
Oh, yes. Sorry. Thank you. And then I guess the bigger point is for the discovery being premature, the stage of discovery being premature, attorneys and respondents don't really have enough information at that time to assess different variables that which may become moot at a later point. And finally, regarding an extension of time, regarding the motion for extension of time to pay, prefacing a reinstatement petition or conditioning a reinstatement petition in order to seek an extension of time to pay does not seem fair or consistent with the purposes of the rehabilitation process. And some petitioners may not seek reinstatement. They might just need an extension to pay. So those are the initial concerns that are being raised. And so the ADDC would appreciate it if we could have an open dialogue to reconcile the assessment of sanctions with the purposes of discipline and join in the conversation in making the amendments as they are presently. We would say that it needs a little bit more work. Thank you.
All right, thank you, Ms. Cha and Mr. Carr. Definitely appreciate working with you on the Bench Bar Coalition, and I think that we'll continue to work out some of these details in that forum and then other forums as well. So are there any other individuals wishing to make public comment? Okay, let's go then to the presentation of item D, proposed new and amended State Bar Rules of Procedure 5.137 and clarification. And Suzanne Grant from Office of General Counsel is presenting on that.
Thank you, Brandon. My name is Suzanne. I'm from the Office of General Counsel. So my presentation will encompass both items 3D and 3E. They're listed as two separate agenda items on the agenda, but we have combined them into one memorandum because they are all amendments to the State Bar Rules of Procedure. However, they were separated out because one is specifically references amendments to Rule 5.137, which is the monetary sanctions rule, and the rest are two amendments to the State Bar Rules of Procedure to implement those monetary sanctions, as well as one amendment to a rule about CSF payments. That's 5.136. In total, there are 23 proposed amendments to the State Bar Rules of Procedure and two new rules that we are proposing. We're seeking a 60-day public comment period for those rules. So I will just briefly go over them. I'll separate them out. First, the amendments to Rule 5.137 itself. That is the rule to implement guidelines for the imposition and collection of monetary sanctions. The original 5.137 was approved by the Supreme Court earlier this year with an effective date of April 1st, 2020. In the process of looking at implementation of those monetary sanctions, we noticed a few things that needed to be clarified. Specifically, we needed to amend the definition of violation to include beyond just violations contained in a notice of disciplinary charges to make sure that there could be monetary sanctions ordered in criminal conviction proceedings, which don't have an NDC. So we wanted to make sure that was included in the definition of violation. We also included a reference to the fact stipulated dispositions also must include an agreement for monetary sanctions to clarify that OCTC and the respondent also had to agree on an amount of monetary sanctions or if they should be waived before presenting that stipulation to the court for the court to sign off on it. And we also added a reference to collection of the sanctions, that we can collect them through any means provided by law. And lastly, the sanctions rule to go into effect for disciplinary proceedings commenced or stipulation signed on or after April 1st, 2020, the effective date of the rule. So the majority of the other proposals relate to the amendments and a couple of new rules to the rules of procedure to implement those sanctions. They're mostly non-substantive. I'm not going to go over every single one because there are so many. In the agenda item before you, they were largely grouped into a few different categories, and those categories reference amendments to rules providing specific notice of the imposition of sanctions. So that would include amending the notice of disciplinary charges, amending the notice that starts the conviction proceedings, amending and the start of the reciprocal discipline proceedings and probation revocation proceedings to alert the respondent that they could have monetary sanctions imposed in their case, as well as alerting them that orders of default would include payment of sanctions. So that was one of them. And then we included the rules, as I stated before in the rule itself, we're proposing to amend the rule to include agreements and the stipulations. So we also proposed amendments to the rules of procedure regarding stipulations to include the fact monetary sanctions had to be agreed upon within the stipulations themselves. And then we also added proposed amendments regarding providing information regarding the amount of sanctions to be sought, which would include the fact the parties have to be prepared to address that during the pretrial conference, that the parties need to present evidence regarding the sanctions, and the fact that the respondent has an opportunity to present evidence why sanctions should not be imposed in their specific case prior to the disposition of the case. And then we also included rules implementing a procedure for cost relief. Rule 5.137 does address the fact respondents can seek a stipulation with OCTC for reduction, waiver, or extension of time for payment after the sanctions have been ordered, or they could file a motion in state bar court. We modeled that after the rules regarding disciplinary costs. They are almost identical, so it's an identical process that lets the respondent seek such type of cost relief after the sanctions have already been ordered. And then I think lastly, we also just needed an amendment to the rule regarding reinstatement to clarify that as a condition of reinstatement, the sanctions had to be paid. And that's also in Rule 5.137. So we needed to amend the rule regarding reinstatement for that. So they're all in attachment A. And lastly, there was one change regarding the client security fund rule. Well, it's a rule of procedure in the state bar that it relates to client security fund payments. And we needed to amend that rule because the rule stated that the state bar court had authority to order payments to the client security fund that were not part of a disciplinary order. The wording of the rule implied that. The state bar court cannot do that because they don't have jurisdiction over client security fund payments unless they are part of a disciplinary order. So we just amended the rule to clarify that. And we also amended the rule to clarify the timing of the payment obligation to CSF. The rule as written stated that it had to be paid within 30 days of disbursement. However, the attorney has an appeal period under the CSF rules that they can file a writ in superior court. So we wanted to make sure the rule was clear that the payment obligation did not start until there was a final order from obligating that they pay back the client security fund. So once again, those are all in attachment A. There's red line versions of all the rules as well as red line of the proposed new rules. So I'd be happy to answer any questions about any of these rule proposals.
All right, does anybody have any questions?
Brandon, I have a question.
Yes, Sean.
So there's a lot of detail here. And this may be for you and Ruben or for Suzanne, I'm not sure, but what's the plan for bringing this back to the board? Is it September or November? I'm just thinking of the length of the public comment period.
We can, I can check the calendar. So let's see. I think if it's 60 days. So the thought behind my question is there's a lot of detail here, and ADDC has given some substantive comments and suggested they might see some ways to amend it. I think it would be prudent to allow enough time after the end of the public comment period and whenever the materials are going to be circulated to the board to try to work this out and package it and have each item of dispute really clearly delineated, like in a table or something. It's a little bit similar to one of the issues we had earlier. So if you want to put this on in September, I think 60 days is too long for the public comment. If it's teed up for November, then you have plenty of time.
The board meeting is September 24.
Yeah, so I think 60 days probably wouldn't give us enough time to get it on September. So I leave that to, you to decide whether you want to shorten it or whether you would rather wait until the next board meeting.
Yeah. Well, is there urgency to it? I mean, we want to get this right. So it may be more suitable to wait till November in terms of the workflow for the board, but that's a fair amount of time too. So can it wait that long?
Yeah, Melanie and Steve, can you address, because I know that we've talked about the way this affects stipulations. Is there an urgency from OCTC standpoint?
I was going to let Melanie address that. Well, it will affect stipulations. I think ultimately the court has we're of the position that respondents and OCTC must stipulate and include it in our stipulations. I think it will complicate those discussions for some period of time, but ultimately, if that's what needs to happen, then that's what needs to happen.
Well, let me try it this way. We have ADDC representatives on the line. Is a 40-day comment period a problem from your standpoint?
Sean, they don't have mic access, so we would need to determine who's going to respond and open a mic for them.
Okay, well, that's up to Brandon. I'll leave that to Brandon then.
Yeah, can we, because I know that I've spoken with Mr. Carr about this, so can we activate Mr. Carr's microphone?
Okay, can you hear me?
Yes.
Okay, yeah, 45 days is really too short a period for public comment. We need probably at least a 60-day public comment period. Unfortunately, our organization moves rather slowly, which you might not expect given our size, but there's a lot of spirited debate that goes on our side of the aisle, so we would prefer a longer public comment period.
All right, thank you, Mr. Carr. All right, any other questions, comments, or motions?
So then, Brandon, did you want to leave it as the 60-day public comment period and then have it go on in November? Is that the consensus?
I think that's what I'm hearing, but if anybody wishes to move the resolution or make amendments, we can address it that way.
Brandon, this is
Brandon,
Ruben. I move it as presented with 60 days for public comment.
Okay.
I'll second. This is
Okay,
Sean.
Ruben. Okay, Ruben with the first, Sean with the second, as to the 60-day public comment period. Any further discussion? Okay, Lisa, please take roll.
Sean? Cisneros?
Aye.
De La Cruz?
Yes.
Duran?
Yes.
Iglesias? LeBron?
Yes.
Manning?
Yes.
Petula?
Yes.
Lloyd?
Yes.
Steinbrecher?
Yes.
All right, motion passes. Thank you. And then Susanna, I believe you're on the next one. Item E.
Oh, that we combine the two. So that was
Okay.
combined in the presentation.
Okay, perfect.
And the resolution, Lisa put both on the screen. So.
Okay, great. Okay, go down to item F. And this is the amendment to CSF Rule 3.434. We have Lori Malak and Matt Zawal online. Can you please deliver this?
Hi, good afternoon. This is Lori Mellock. I'm the Program Director of the Office of Professional Support and Client Protection. Matt Zawal, the Supervising Attorney for Client Security Fund, worked on this with Suzanne, so I'll just turn it over to him to present.
Thank you, Lori. Good afternoon. Well, as a follow-up to Suzanne's presentation, Rule 5.137 calls for collected monetary sanctions to be deposited into the Client Security Fund, and that follows the enabling legislation, Business and Professions Code 6086.13. What we're seeking today is to circulate for public comment a proposed Client Security Fund rule that will enable us to distribute collected sanctions in accordance with that code section and the rules, which allow the Client Security Fund to reimburse victims of the attorneys who hold criminal sanctions or judgments, and only if the judgments are uncollected, the criminal sanctions or judgments are uncollected. So if they hold them and they're uncollected and the state bar actually collects monetary sanctions against the attorney, then the Client Security Fund may reimburse those people to the extent of the collected sanctions.
All right, thank you. Any questions? All right, hearing none, may I have a motion?
So moved. This is Ruben.
Second, Alan Steinberger.
Okay, first by Ruben, second by Alan. Lori, please call the roll.
All right, Lisa. Chen? Cisneros?
Aye.
Dela Cruz? Dela Cruz? Duran?
Yes.
Iglesias? LeBron?
Yes.
Manning?
Yes.
Petula?
Yes.
Blake?
Yes.
Steinberger?
Yes.
Okay, did Dela Cruz drop off? Because I didn't.
Yes, he had to drop off for a period, I think.
You have 7 votes. You have 7.
All right, motion passes. Thank you, everyone, for your work.
Thank you.
All right. Just a brief comment about item G. This is something that we'll continue to work with State Bar Court on. Happy with the progress that's being made, but we didn't feel like it was ready to bring to the board just yet. So I think in September, we'll have this back on our radar. As to H and I, in the interest of time, Lisa, are we okay tabling this to next meeting?
Yes.
Okay, any objection to tabling H and I to next meeting? All right, seeing none. Okay, we still have the 2201 administrator report that will be given in closed session. However, we do have a noticed joint meeting of RAD and XCOM in closed session. And so what I would propose is to go to the joint meeting first. We will reconvene in closed, and then when we come out of the joint meeting, then we'll go back into closed depending upon the hour and get an update from Jeff. So I don't know if Jeff's on the line, or Lisa, if you know his schedule, if that would work.
I can find out. Do you,
Okay. Did anybody have an objection to going first to the joint meeting and then to a 2201 report? Okay, hearing none. So we will we'll take a recess from the RAD agenda. We'll convene into closed for a joint RAD and executive committee meeting, and that is pursuant to Government Code Section 11126 sub A sub 1. All committee members should have received a link to that closed Zoom meeting. So we will.
Apologies for being overly bureaucratic. We asked about this. I think you do need to convene the joint meeting as a separate meeting.
Yes.
I noted that your adjournment of the RAD meeting, and I think we are going to need to take roll. For
Okay, so
it's the same cast of characters, but we need to.
Got it. Okay, so we will take a recess then from RAD, and now I will convene the joint meeting of RAD